Ask unanimous consent the quorum call be dispensed with.
Without objection.
Thank you, Mr. President. Nearly 3 months ago, I came to the Senate floor for the first time to support President Trump's nomination of Brett Kavanaugh to the United States Supreme Court. Here's what I had to say at that time. Quote, Judge Kavanaugh is among the most distinguished and most influential judges in the Supreme Court in the entire country. The Supreme Court has adopted the positions in his opinions no less than 11 times. He has authored multiple dissents that ultimately prevailed in the Supreme Court. He has taught courses at Harvard Law School, at Yale Law School, and Georgetown's Law School. And it bears mention, liberal and conservative justices alike have hired his former clerks, which shows the respect he has across the ideological spectrum. Truly, Mr. President, there is no one more qualified and more prepared to serve on the Supreme Court than Brett Kavanaugh, unquote. A lot has transpired in the last 3 months. We've received and reviewed more documents for Judge Kavanaugh than for any other Supreme Court nominee in our nation's history. We've had 5 days of public hearings. Judge Kavanaugh has answered more than 1,300 written questions, more questions than all previous Supreme Court nominees combined. We've had protesters in halls and hearing rooms and elevators. We've even seen the miraculous return of Spartacus. And, Mr. President, we've had the lowest, most vile, most dishonest attempt at character assassination that I've ever seen in my whole 42 years service in the United States Senate. We may never know who leaked reports of Dr. Ford's allegations to the press. We do know that it was someone in the Democratic orbit. This was followed by the most appalling smear campaign imaginable. No accusation was too heinous, no claim too far-fetched. My Democratic colleagues like to pretend that Judge Kavanaugh's understandable indignation at last week's hearing was a reaction only to Dr. Ford's allegations, but of course, that's not the case. In the days immediately preceding that hearing, Judge Kavanaugh was accused of drugging women, of sexual assault, and even gang rape. And Judge Kavanaugh told the committee investigators it was like the Twilight Zone. I sure wish my Democratic colleagues would stop trying to rewrite history to excise the slew of garbage they unleashed on Judge Kavanaugh and the American people. And I hope that they'll start talking to their friends on the outside, to start acting like Americans again, and to quit this kind of divisive activity. I'd like to say a word here about Dr. Ford. It's clear now that we'll never know what happened 36 years ago. Dr. Ford offered a moving account of what she says happened between her and Judge Kavanaugh back when they were teenagers. Judge Kavanaugh, in turn, offered a forceful, impassioned rebuttal of her claims. Some have criticized Judge Kavanaugh for being too forceful in his response. My gosh, if that was me, I would be even more forceful than he was to have false accusations like that, especially at this particular time in this process. Interestingly, almost without exception, these critics had announced their opposition to Judge Kavanaugh even before Dr. Ford's allegations were leaked to the press. So let's not pretend these critics are neutral observers. And in any event, Judge Kavanaugh's indignation of what he clearly believes are false and unjust accusations was both understandable and, in my view, entirely proper. Dr. Ford's allegations are serious. If true, they should disqualify Judge Kavanaugh from serving on the Supreme Court. But neither Dr. Ford, nor her attorneys, nor any member of the news media has been able to provide any corroboration for her claims. To the contrary, every alleged eyewitness or partygoer that she is named has either denied her allegations or failed to corroborate them. This includes her lifelong friend Leland Kaiser, whom Dr. Ford says was present at the party that night. Ms. Kaiser says that not only does she not remember such a gathering ever taking place, but that she does not even know Judge Kavanaugh. Questions have been raised in recent days about certain elements of Dr. Ford's testimony. She says she first told others that Judge Kavanaugh had attacked her around the time of a house remodel to add a second front door to her home. But permit records show the door was added 4 years prior to her first alleged mention of Judge Kavanaugh. She testified she'd never given advice on how to take a polygraph test. A former boyfriend of hers, however, disputes that statement. Dr. Ford has also offered inconsistent accounts of when the attack took place and how many people were present at that party. There are other aspects of her story that are also confusing. She does not remember where or when the attack took place, but she remembers with crystal clarity how much alcohol she had consumed. This appears to be the only fact unrelated to the alleged attack that she is able to recall with certainty. Dr. Ford also testified that after the attack, she ran out of the party. The location of the party would have had to be some distance from her home. She was too young to drive, so she would have had to have gotten a ride home. But she does not recall who drove her home. And given that this was long before the era of cell phones, it's unclear how she would have contacted someone to come pick her up after she ran out of the party. Even more puzzling, her good friend, Ms. Kaiser, apparently never asked Dr. Ford why she disappeared from the party. Now, given that there is no corroborating evidence for Dr. Ford's claims, all we have to go on is her story. Although not dispositive, the questions and inconsistencies and puzzling aspects that I have just outlined call into question the reliability of her account. This is simply not enough, Mr. President, to conclude that Judge Kavanaugh is guilty of the heinous act Dr. Ford alleges. It flies in the face of the life he's lived as a judge and how effective he's been as a judge on the second highest court in the land. Against the thinness of Dr. Ford's accusations, we have an entire lifetime of good works and honorable public service by Judge Kavanaugh. We have received dozens of letters and hundreds of people attesting to Judge Kavanaugh's good character and unimpeachable credentials. His clerks, students, and former colleagues have all praised him as a man of the highest integrity. He has made the promotion and encouragement of women lawyers a focus of his time on the bench. He volunteers in his community and mentors young athletes. This is a good man. He's a very good man, and he does not deserve this kind of treatment or behavior. What Dr. Ford alleges is entirely out of character with the entire course of Judge Kavanaugh's life. The recent sideshow stories about his drinking habits in high school, my gosh, in college, over 30 years ago, from people who never liked him in the first place, are just a distraction. That this confirmation process has turned into a feeding frenzy about how nice Judge Kavanaugh was to his freshman roommate is an embarrassment. That said, the Senate has taken these allegations seriously, as we should. We invited Dr. Ford and Judge Kavanaugh to testify, and they did so. Committee investigators spoke with numerous individuals who said they had relevant information to share. The committee also took statements under penalty of felony from the alleged witnesses Dr. Ford named. In addition, the FBI recently completed a supplemental background check of Judge Kavanaugh, And the FBI found no collaborating evidence for any of the recent allegations against Judge Ford, or Judge Kavanaugh, excuse me. Let me repeat that. And the FBI found no corroborating evidence for any of the recent allegations against him. Not a single piece of corroborating evidence. Now that the FBI has found no corroborating evidence, some of my Democratic colleagues shamefully have taken to calling into question the credibility of the FBI and its investigators. These attacks are irresponsible, to say the least. Indeed, contrary to what my Democratic colleagues have said, the FBI conducted a thorough, professional, and expeditious investigation. The FBI talked to the people it needed to talk to. What agents did not do is talk to someone who says he talked to someone more than 30 years ago who now doesn't remember seeing anything. They didn't investigate whether Judge Kavanaugh was in fact spotted near a punch bowl at a high school party. And they were right not to do so. An FBI investigation is not a wild goose chase. Some of my Democratic colleagues are also complaining that the FBI did not interview Dr. Ford or Judge Kavanaugh during the supplemental investigation. Well, Dr. Ford testified in a public hearing for nearly 3 hours. She told the committee that she had given us all of the information she could remember. The FBI does not need to repeat questions that have already been asked and answered, particularly when a person has already said she shared everything she can remember. Judge Kavanaugh likewise testified publicly at the hearing. He also spent several hours answering questions from committee investigators under penalty of felony on several different occasions. He has been thoroughly interrogated under oath in public and in private about these allegations. Some of my Senate Judiciary Committee colleagues made the unfortunate choice last night to smear Judge Kavanaugh with yet another piece of innuendo. 8 members of the committee sent a letter in which they incorrectly implied that the 6 previous background checks on Judge Kavanaugh contained information concerning sexual improprieties or alcohol abuse. In so doing, they took advantage of rules to protect the confidentiality of witnesses to score cheap political points. Although we should all be disquieted by my colleagues' unscrupulous conduct, the American people can rest assured that no such information exists. If it did, Democrats would have raised it before now. Of that, we can certainly be certain. Indeed, Mr. President, after weeks of nonstop mudslinging and attempted character assassination by Senate Democrats and their media allies, no one has been able to find any charge against Judge Kavanaugh that sticks. And you can believe they've tried. Boy, can you believe they've tried. This has been the worst example of the Washington smear machine that I've seen in all my 42 years of Senate service. So we're left back where we were before this whole sordid saga began. Judge Kavanaugh is eminently qualified, unquestionably qualified to serve on our nation's highest court. He is among the most distinguished, influential judges in the entire country. His opinions have received widespread acclaim and have won approval by the Supreme Court on multiple occasions. Multiple occasions. The American Bar Association interviewed more than 100 fellow judges and lawyers who know Judge Kavanaugh and who have appeared before him, and they all spoke with virtual unanimity in praising his integrity, his work product, and his judicial temperament. As somebody who tried cases in federal court, I would have been happy to have had Judge Kavanaugh, who I know would give a fair shake to both sides. He's the kind of a judge I would have admired in every way, and I do. But I would have admired him in every way as a practicing trial lawyer who had quite significant experience. I hold the highest rating, the AV rating from Martindale-Hubbell, which is the rating service that rates attorneys without their knowledge by going to other top lawyers in their areas. And I've had that highest rating in 2 states, in Pennsylvania and in Utah. So I take these matters very seriously. I believe in the federal courts. I think they do a terrific job in this country. I have nothing but admiration for them. There are very few exceptions. And I think it's just a terrible, ridiculous problem that has arisen here because people are playing politics with this judge and this judgeship. I'm sorry that Judge Kavanaugh has had to go through this ordeal. He did not deserve this. He is a good man. He spent decades building a reputation of decency and fairness. His opponents have attempted to destroy it with 3 weeks of smut and unsubstantiated allegations. It makes me sick to see this type of stuff. And certainly does when some of my colleagues buy into it, which they shouldn't. They should not. But I know Brett Kavanaugh. I know him well. He's a man of great resilience and firm conviction. He is going to be a great justice, perhaps one of the greatest we've ever had. He will bring to the Supreme Court the integrity, honor, and intellectual rigor he has demonstrated throughout his entire career. And soon enough, he will have rebuilt his reputation. He will earn the respect of his colleagues and the American people through his writings and his decisions. Of that, I have no doubt. Mr. President, I will vote to confirm Judge Kavanaugh. He is unquestionably qualified. He has gone through the most thorough vetting process I've ever seen. And it's been a miserable, wretched process in some respects. But he's come through. And we'd all give him credit for that. Hundreds of thousands of documents produced, 5 days of hearings, 7 FBI background checks. We know what we need to know. The American people know what they need to know. It's time to vote. It's time to confirm this good man to the United States Supreme Court. And I hope this body will get to that decision-making process as soon as it can. It's time to end this charade. It's time to back this really good man. And I predict he'll make one of the great justices on the United States Supreme Court. And I'm grateful to my colleagues who have given him the benefit of the doubt and who know him and know that these things are not true. And I'm grateful for the privilege of serving in the United States Senate. I'd sure hate to end my service with further smears to a good man like Judge Kavanaugh. Mr. President, I yield the floor.
Mr. President.
Senator from Maryland.
Thank you, Mr. President. Mr. President, I have read the FBI report. I've listened to the Judiciary Committee hearings, including the second hearing with Dr. Ford and Judge Kavanaugh. I've reviewed Judge Kavanaugh's opinions as a judge and his public record during his tenure in the White House. Based on his record, I cannot support his nomination for a lifetime appointment to the Supreme Court of the United States. I reached this conclusion before Dr. Ford's allegations were made, based on his court opinions and White House record. That conclusion was reinforced by Judge Kavanaugh's testimony in response to Dr. Ford's powerful and compelling testimony, raising very serious issues concerning Judge Kavanaugh's conduct. Judge Kavanaugh's response demonstrated his lack of impartiality and temperament, which is a critical qualification to serve as a judge. That view was reinforced by a letter written by over 1,000 law professors and legal scholars, reaching the same conclusion that I had drawn. I was very disappointed by the process on Judge Kavanaugh's nomination that was dictated by the Republican leadership. For Senator McConnell, 10 months was inadequate time for the Senate to consider President Obama's choice of Judge Merrick Garland to the Supreme Court of the United States. Yet Senator McConnell had no difficulty in rushing the consideration of Judge Kavanaugh through the Senate in a fraction of that time. The Republican leadership refused to demand a complete discovery of relevant documents concerning Judge Kavanaugh. I served on the Judiciary Committee during the consideration of Justices Sotomayor and Kagan, when the Republicans' request for complete discovery was honored and welcomed by the Democrats. Such was not the case in regards to the Republicans honoring reasonable requests for information concerning Judge Kavanaugh. To make matters worse, the chairman of the Judiciary Committee inappropriately and unilaterally classified certain documents as confidential, preventing their public use during the confirmation process. After Dr. Ford's allegations became public, the Republican leadership refused to allow the FBI to conduct a proper investigation before scheduling a rushed, inadequate, and incomplete hearing without any additional witnesses beyond Dr. Ford and Judge Kavanaugh. The Republican leadership refused to call before the committee eyewitnesses to the allegation. Prior to the first hearing and before I had reached a conclusion on the nomination, I had requested an opportunity to meet one-on-one with Judge Kavanaugh, which is the Senate tradition on Supreme Court nominees. That request was denied by the White House. I cannot support Judge Kavanaugh because of his judicial record, his partisan leanings, and his lack of impartiality and judicial temperament. I am concerned that Judge Kavanaugh is inclined to turn back the clock on civil rights and civil liberties, voting rights, reproductive choice, equality, the Affordable Care Act, workers' rights, clean air and clean water, and protection from abuses of corporate and political power, including the President of the United States. Our Constitution created the Supreme Court as an independent check and balance against both the executive and legislative branches of government. It should not be a rubber stamp on presidential efforts to undermine the rule of law or independence of the judiciary, self-pardon, or derail special counsel Mueller's investigation into Russia's interference in our 2016 elections. The next justice of the Supreme Court should not be predisposed to enrich corporations at the expense of consumers or hollow out protections for Americans against abuse of power, as Judge Kavanaugh's record as an appellate judge reveals. Judge Kavanaugh has advanced legal theories as part of an activist agenda to overturn longstanding precedent to diminish the power of federal agencies to help people, and he has demonstrated an expansive view of presidential power that includes his belief that presidents should not be subject to civil suits or criminal actions. So, Mr. President, let me turn to some specific policies in Judge Kavanaugh's record that concerns me should he become Justice Kavanaugh. To point out what I've just said, I look at the opinions and writings that he has done. There are concerns that Judge Kavanaugh's nomination could present a conflict of interest on the ongoing investigation of the Russians' interference in the 2016 presidential elections, as the Supreme Court could be asked to rule on whether Special Counsel Robert Mueller has the right to subpoena the president to testify. In his confirmation hearing, Judge Kavanaugh refused to say whether he would recuse himself from this case should it reach the court. I would hope that the Supreme Court would indeed compel President Trump to comply with any reasonable subpoena from the special counsel, citing the precedent of requiring President Richard Nixon to surrender tapes and other evidence during the Watergate investigations. The Supreme Court ultimately held that the president was not above the law. Some comments of Judge Kavanaugh suggest that he believes the Nixon case was wrongly decided. There's also concerns that a Justice Kavanaugh would defer criminal investigations and prosecution of presidents' misconduct until after President Trump leaves office. Ironically, his views on presidential power has changed since he worked for the independent counsel Kenneth Starr on the Whitewater investigation of President Bill Clinton. Indeed, Judge Kavanaugh wrote that a sitting president should have absolute discretion to determine whether and when to appoint or remove a special counsel. But it's clear that Judge Kavanaugh holds a troubling record when it comes to presidential power. In the case of Seven Sky versus Holder, pertaining to our country's health care system, Judge Kavanaugh's opinion implied that if he believes the president does not have to enforce laws if the president deems a statute to be unconstitutional, regardless of whether or not the court has already held it constitutional or not. Judge Kavanaugh was asked in 2016 if he could overturn precedent in any one case, and he said he would put the final nail in Morrison versus Olson, which upheld the constitutionality of the independent counsel statute. It appears that Judge Kavanaugh believes that the president is above the law, and only remedy for presidential misconduct in office is impeachment by Congress, as suggested in some of his writings in 2009. He wrote that we should not burden a sitting president with civil suits, criminal investigations, or criminal prosecutions. That's a direct quote. And that the country loses when the president's focus is distracted by burdens of civil litigation or criminal investigation and possible prosecution. Mr. President, no one's above the law, including the President of the United States. We know that President Trump has deep disregard for the rule of law. He constantly criticizes his own Justice Department, including urging the Justice Department to prosecute or not prosecute certain individuals. He has criticized the special counsel investigation into Russia's interference in our election as a witch hunt, notwithstanding the growing number of convictions and guilty pleas obtained by Mr. Mueller. He has explored whether he has the power to pardon himself, family members, or associates. The future status of Rod Rosenstein, the Deputy Attorney General who supervises the special counsel investigation, is in jeopardy, as President Trump has made it known he would like Mr. Rosenstein to go. We need a Supreme Court justice that can stand up to the president, stand up for the rule of law, stand up for the independence of the judiciary. Based on his track record, I'm not convinced that a Justice Kavanaugh would do that. While serving on the Court of Appeals for the D.C. Circuit, Judge Kavanaugh considered the constitutionality of the Affordable Care Act of 2011. The court upheld the constitutionality of the Affordable Care Act by a 3-0 vote, and Judge Kavanaugh wrote a concurring opinion. His concurring opinion has been described as the roadmap challenging the constitutionality of the Affordable Care Act. In his opinion, Judge Kavanaugh argued that it was premature to hear the case before the individual mandate had taken effect. Judge Kavanaugh laid out the legal justification for President Trump not enforcing the individual mandate and for a judicial challenge to the constitutionality of the Affordable Care Act. A Justice Kavanaugh would raise significant concerns as to how he would rule on the protections in the Affordable Care Act against insurance companies discriminating on pre-existing conditions, which could affect millions of Americans. In June of this year, President Trump's Department of Justice broke with longstanding department president and decided it would no longer defend the Affordable Care Act. In a brief filed by the Trump administration in Texas versus the United States, the administration joined with 20 Republican-led states to argue that the Affordable Care Act protections for people with pre-existing conditions should be invalidated. In their court filing, the administration argued that when the Republican tax bill eliminated the individual mandate, the taxless individual mandate became unconstitutional, and therefore the law's protection for those with pre-existing conditions, including guaranteed issue and community rating, should be unenforceable. Well, in 2017, Health and Human Services released a report stating that as many as 133 million non-elderly Americans have a pre-existing condition. Every one of them would be at risk if this protection is held to be invalid by the Supreme Court. The Maryland Health Benefit Exchange estimates that in Maryland there are approximately 2.5 million non-elderly Marylanders with pre-existing conditions, including 320,000 children, all at risk. In addition to Texas versus U.S., there are dozens of healthcare cases pending in lower courts, which are likely to be appealed to the Supreme Court in the upcoming terms. The outcome of these cases in the Supreme Court will directly impact access to health care for millions of American families, including the most vulnerable in our society. In each of these cases, there is a question about whether the Affordable Care Act creates rights that individuals can enforce in court. These cases deal with critical issues, such as the scope of health care coverage for nursing mothers, false advertising by health insurance companies, and whether employers are required to provide health coverage to their employees. Given Judge Kavanaugh's stated hostility to the Affordable Care Act, I fear that Justice Kavanaugh would further restrict access to health care for many Americans, particularly in regards to women's health care, including birth control. In Planned Parenthood versus Casey, the Supreme Court firmly established the constitutional right to privacy protects women from undue burdensome interference with her freedom to decide whether to terminate her pregnancy. This standard is known as the undue burden standard, prohibits a government action that has the purpose or effect of placing a substantial obstacle in the path of women seeking an abortion on a non-viable fetus. Judge Kavanaugh wrote in the dissent of Garza versus Hargan in 2017, supporting the Trump administration's ongoing efforts to prohibit a pregnant immigrant teenager in government custody from exercising her constitutional rights to make her own health care decisions. Judge Kavanaugh pays lip service to the undue burden standard articulated in Casey. He shuns long-standing precedent and chooses instead to impose his own moral standards on Jane Doe. In a heated dissent in Priests for Life versus HHS, Judge Kavanaugh argued that the Affordable Care Act's existing accommodations for religious employers who wanted an exemption from the contraception coverage policy still placed a substantial burden on the employer's beliefs. Multiple cases concerning women's access to birth control are working their way through the court. Justice Kavanaugh could become the decisive vote on the Supreme Court in limiting access to reproductive care. Maryland is home to many rivers which are part of the vast Chesapeake Bay watershed. The land and waterways that supply our drinking water, support our native ecosystems, and contribute to our tourism and local economies are all at stake. Whether allowing more toxins in our air or more nuclear waste in our backyard, Judge Kavanaugh has prioritized corporate America over the health of American citizens and our environment. Justice Kennedy understood the values of Americans when weighing the cost and benefit of environmental protection. Judge Kavanaugh has not shown such concern for balancing values and interests. The Clean Air Act, which dramatically reduced these toxins after its passage in 1970, has prevented over 400,000 premature deaths, 1 million bronchitis cases, 2 million asthma attacks, and over 40 million children respiratory illnesses. Judge Kavanaugh heard several major cases about the EPA's authority under the Clean Air Act. And in each of these cases, he opposed the agency position. These protections should be strengthened, not eroded. As a lifelong Marylander and as a senior member of the Environment and Public Works Committee, I have prioritized the protection of the Chesapeake Bay. Thus, I have worked to defend the EPA's Clean Water Rule, which has come under attack by Republican legislators and opponents in this administration. 67% of Marylanders get their drinking water from sources that rely on small streams that are protected under the Clean Water Act. Partisan and short-sighted threats put our environment, economy, and public health in danger. If these attacks prove successful, protecting our citizens from the danger of water pollution will become far more difficult. So we're left with even more uncertainty with Judge Kavanaugh's nomination. Would he support the Clean Water Rule, which would protect the drinking water sources of 100 million Americans by making sure they are regulated under the Clean Water Act? We can all agree few responsibilities of our government are more fundamental than clean, safe water. But I'm not certain that Judge Kavanaugh would defend this duty in the Supreme Court. As a member of the D.C. Circuit Court, Judge Kavanaugh ruled in a number of high-profile cases to limit EPA's protection on issues like climate change and air pollution, and against Maryland's interest as a coastal downwind state. He has consistently voted against environmental regulations and often in favor of corporate interests. Judge Kavanaugh's environmental jurisprudence is rife with double standards, as he has frequently attempts to insert cost considerations into environmental regulations where none exist in statute. Furthermore, he places a very low burden of proof on businesses claiming injury from regulation, while at the same time asserting a much higher standard of proof for citizens, arguing that pollution is sufficiently harmful to warrant regulation. The following cases involve Judge Kavanaugh's document his support of the powerful interests over public interests in the area of public health and the environment. In EME Homer City Generation versus EPA, Judge Kavanaugh wrote an opinion overturning an EPA rule designed to lower smog-forming sulfur dioxide emissions by 73% and nitrogen oxide emissions by 54%. The Supreme Court later ruled in favor of EPA and overruled Judge Kavanaugh's opinion. Nitrogen oxide accounts for 2/3 of the airborne nitrogen that ends up in the Chesapeake Bay. In the case of the Coalition for Responsible Regulations versus EPA, Judge Kavanaugh dissented from a decision not to rehear a case which was found that the EPA had the ability to regulate emissions in order to slow climate change. In the case of White Stallion Energy Company versus EPA, in a dissent, Judge Kavanaugh insisted that the EPA must take costs to business into account when judging regulation, attempting to argue that instead of determining what's in the best interest of public health, EPA should be determining what is the least costly to business. In Clean Air Council versus Pruitt, Judge Kavanaugh dissented in a D.C. Circuit determination that the EPA was unreasonably delaying the implementation of a 2016 rule that curbed fossil fuel emissions of methane, smog-forming volatile organic compounds, and toxic air pollutants. In Mexican Florin versus EPA, Judge Kavanaugh sided with producers of hydrofluorocarbons, saying EPA had no authority to regulate that. In Mingo Logan Coal versus EPA, Judge Kavanaugh dissented again, arguing that the EPA must weigh the cost of business in revoking a clean water air permit. In each of these cases, Judge Kavanaugh sided with corporate interest over public health. There is a clear record here. My concerns about Judge Kavanaugh also include his lack of sensitivity to the protections of civil rights. In the case of South Carolina versus Holder, Judge Kavanaugh ruled that South Carolina voters' ID law was not discriminatory and did not violate the Voting Rights Act. South Carolina residents are required to use driver's license, passport, military ID, or voter registration cards to vote. Judge Kavanaugh disregarded Section 5 of the Voting Rights Act and impedes on the voting rights of minorities that are impacted by the South Carolina voting laws. We all know how difficult it is with minority communities when you have these ID laws. We know how difficult it is for older people to get to places to get those types of identification. This sends a dangerous signal about Judge Kavanaugh's view on voting rights and racial justice in America. Judge Kavanaugh's ideological bias can also be seen in his rulings in employment discrimination cases, where he has dissented and voted to dismiss claims that a majority of his D.C. Circuit colleagues found to be meritorious. In Howard versus Office of Chief Administrative Officer of the United States House of Representatives, Judge Kavanaugh dissented from a majority decision which held that under the Congressional Accountability Act, an African-American woman fired from her position as a House of Representatives Deputy Budget Director could pursue her claim of racial discrimination and retaliation in federal court, giving her a right of action. Judge Kavanaugh dissented from that. He argued that the speech or debate clause of the Constitution prohibits the employees from moving forward with her claim and would have dismissed the case. His interpretation of this constitutional provision would bar workers in congressional offices and throughout the legislative branch from pursuing most of their discrimination claims in federal court, including many sexual harassment, discrimination, and retaliatory claims, leaving an inadequate and secret remedy only available. In Miller versus Clinton, The majority held that the State Department violated age discrimination in Employment Act when it imposed a mandatory retirement age and fired an employee when he turned 65. The State Department argued that it was exempt from this statute in light of a separate federal law that permits U.S. citizens abroad to be exempt from U.S. anti-discrimination laws. The majority disagreed and held that there was nothing in the Basic Authorities Act that abrogates the broad prescription against personnel actions that discriminate on the basis of age, and that the necessary consequences of the department's position is that it also free from any statutory bar against terminating an employee like Miller solely on account of his disability or race or religion or sex. Judge Kavanaugh dissented, arguing that the Basic Authorities Act overrules existing anti-discrimination laws. His willingness to embrace such a broad exemption from anti-discrimination laws is troubling. Once again, Mr. President, we see a pattern in Judge Kavanaugh's rulings, favoring the powerful over individual rights. In Radigan versus Holder, Judge Kavanaugh dissented from a majority decision which ruled that an African-American FBI agent could pursue a case of improper retaliation for filing a discrimination claim when the agency started security investigations against him, as long as he did so without questioning unreviewable decisions by the FBI Security Division. He stated that the entire claim must be dismissed, despite the majority's warning that this was not required by precedent and the court should preserve to the maximum extent possible Title VII's important protection against workplace discrimination and retaliation. Judge Kavanaugh was in the minority on that opinion. Judge Kavanaugh's dissents in these cases embrace positions that carve out federal employees from protection of federal employment discrimination laws or limit their ability to enforce those rights. Judge Kavanaugh has a pattern of rulings against workers and employees in other types of workplace cases as well, such as workplace safety, worker privacy, and union disputes. Let me cite a few examples. In SeaWorld of Florida versus Perez, Judge Kavanaugh once again dissented from a majority opinion, upholding a safety citation against SeaWorld following the death of a trainer who was working with a killer whale, which had killed 3 trainers previously, while the majority deferred to the Occupational Safety and Health Review Commission's finding that SeaWorld had insufficiently limited the trainer's physical contact with the whales. Judge Kavanaugh strongly disagreed and questioned the role of government in determining the appropriate level of risk for workers. In National Labor Relations Board versus CNN, Judge Kavanaugh once again dissented in part from Chief Judge Garland's majority opinion, upholding a National Labor Relations Board order that CNN recognize and bargain with worker unions and finding that CNN violated the National Labor Relations Act by discriminating against union workers in hiring. Judge Kavanaugh dissented from the finding that CNN was a successor employer, and in his position would have completely absolved CNN of any liability for failing to abide by its collective bargaining agreements. In the National Federation of Federal Workers versus Vilsack, Judge Kavanaugh once again dissented from the D.C. Circuit majority ruling, which invalidated a random drug testing program for the U.S. Forest Service employees at Job Corps civilian conservation centers. The majority, which included another Republican-appointed judge, observed that there was no evidence of any difficulty maintaining a zero-tolerance drug policy during the 14 years before the random drug testing program was adopted, and that the primary administrator of Job Corps, the Department of Labor, had no such policy. That didn't affect Judge Kavanaugh. He dissented and would have restricted employees' privacy rights. In American Federation of Government Employees versus Gates, Judge Kavanaugh authored the majority opinion that reversed the lower court's partial blocking of the Department of Defense regulations, which would have found that many Pentagon regulations would entirely eviscerate collective bargaining. Judge Kavanaugh disagreed. Judge Tattle dissented in part, noting that Judge Kavanaugh's majority opinion would allow the Secretary of Defense to abolish collective bargaining altogether, a position which even the Secretary disagrees. After the Supreme Court decision in Heller,
5-4 decision in 2008 that the Second Amendment protects an individual's rights to bear arms. D.C. passed a law that prohibited assault weapons and high-capacity magazines that require certain firearms to be registered. This is what we know: the Heller decision. We know the importance of the Heller decision extending individual rights under the Second Amendment. But after the district passed a law involving assault weapons and high-capacity magazines, the same plaintiff, Richard Heller, argued that the new gun law violated the Second Amendment. In the 2011 case of Heller versus District of Columbia, a panel of 3 Republican-appointed judges ruled 2-1 that the D.C. ban on assault weapons and high-capacity magazines were constitutional. It happened to be 3 Republican-appointed judges. The ruling was 2-1. You guessed it, Judge Kavanaugh was the dissenter and would have held that the ban on assault weapons was unconstitutional. He wrote in that opinion that there is no difference between handguns and assault weapons in that regard. Well, Mr. President, I find that very troubling if he does not see a difference between a handgun and an assault weapon. Justice Kavanaugh would worsen the problems caused by the Supreme Court's decisions in Citizens United, which gave corporate speech First Amendment protections, increasing the flow of money into our elections. His record indicates he would continue opening the floodgate of dark and secret money in our political system. We have enough money already in the system. We don't need more. And a Justice Kavanaugh, to me, be open seasons on more special interest money getting into our election system. In the case of Emily's List versus the Federal Election Commission, Judge Kavanaugh wrote the opinion for a conservative 3-judge panel that struck down the FEC rules developed to address the influx of spending by outside groups and paved the way for the creation of super PACs. Judge Kavanaugh has been critical of the Chevron deference. Under Chevron, which is named for the 1984 Supreme Court opinion, courts defer to reasonable agency interpretations when Congress has been silent or ambiguous on an issue. In a 2017 speech at Notre Dame honoring Justice Scalia, Judge Kavanaugh said, "The Chevron doctrine encourages agencies' aggressiveness on a large scale. Under the guise of ambiguity, agencies can stretch the meaning of statutes enacted by Congress to accommodate their preferred policy outcomes. I saw this firsthand when I worked in the White House, and I see it now as a judge." Judge Kavanaugh's proposed solution to the Chevron is to simply determine the best reading of the statutes. Courts would no longer defer to agencies' interpretation of statutes. Such an interpretation would put environmental, public health, and consumer protection interests at grave risk. Judge Kavanaugh would have struck down the Consumer Financial Protection Bureau as unconstitutional when he wrote the majority opinion in a panel decision. And an en bloc panel of the D.C. Circuit ultimately vacated that and remanded Judge Kavanaugh's decision, upholding the constitutionality of the Dodd-Frank reforms, including the Consumer Financial Protection Bureau. But that's what's at risk with a Justice Kavanaugh. Those types of decision-making that further consumer protection, public health, and environmental issues. The purpose of the Chevron doctrine is to allow government agencies to carry out congressional intent as our agencies are carrying out and interpreting increasingly complex statutes. Judicial review of such interpretations is governed by a 2-step framework that was included in the Chevron case. The Chevron framework of review usually applies if Congress has given an agency the general authority to make rules with the force of law. If Chevron applies, a court asks at step 1 whether Congress directly addressed the precise issue before the court using traditional tools of statutory construction. If the statute is clear on its face, the court must effectuate congressional intent. However, if the court concludes instead that the statute is silent or ambiguous with respect to the specific issue, the court proceeds to Chevron step 2. At step 2, courts defer to the agency's reasonable interpretation of the statute. This is just common sense. Even the late conservative Justice Anthony Scalia defended the Chevron doctrine as an important rule of law principle. As the Leadership Conference on Civil and Human Rights has stated, federal agencies issue regulations addressing a wide array of civil and human rights issues, including environmental protection, immigration policy, health care protection, education laws, workplace safety, and consumer protection. Justice Kavanaugh will put all of these protections at risk. Judge Kavanaugh's performance at his hearing and his answers to questions for the record did not provide me any additional comfort about his nomination. Indeed, Judge Kavanaugh's testimony, judicial record, and legal career reveal a disturbing pattern. I believe he would be a justice with an activist conservative agenda who could disregard precedent to reach a desired outcome. Justice Kavanaugh could serve as a rubber stamp for the worst successes of the Trump administration. Judge Kavanaugh has several opportunities to stand up for the independence of the judiciary and the rule of law. He has refused to condemn President Trump's attack on Justice Ginsburg or Judge Curl due to his Mexican heritage. I recall, by contrast, when we had Judge Gorsuch before us with his confirmation hearings, that he said, when anyone criticizes the honesty or integrity and the motives of a federal judge, well, I find that disheartening. I find that demoralizing because I know it's not the truth. Judge Kavanaugh wouldn't even go that far. Judge Kavanaugh refused to comment on President Trump's repeated attempts to politicize criminal prosecution or the Department of Justice. His testimony following Dr. Ford's testimony is particularly troubling. His tirade against members of the Judiciary Committee, his partisan attacks, and his conspiracy theories reveal real concern to me about his impartiality and judicial temperament, and whether he would be a partisan on the court. The American people want an independent voice on the Supreme Court to protect their individual rights against those in power, be it the president or powerful corporate interests. Under our Constitution, the courts must act as an independent branch of government, as a check and balance against the abuse of power. The Supreme Court is the guardian of Americans' constitutional rights against the powerful. After reviewing Judge Kavanaugh's record, I believe he's not the right choice to safeguard these fundamental principles. I will vote no on his confirmation to the Supreme Court. With that, Mr. President, I would suggest the absence of a quorum.
The clerk will call the roll.